which is also a discussion that has come up time and again, whether an act of parliament could amend Article 88 to delegate prosecutorial authority to another institution. That's the legal question there. Can an act of parliament, or can parliament make a law to change a provision of the constitution, by which change, the effect of which change would be to take away some of the powers of the Attorney General and vest it in a different institution, the OSP? That's question number one.
Right.
And in the opinion of the Attorney General, ordinary legislation cannot do that. You cannot use an act of parliament to do that. And check the choice of word there. Prosecutorial powers may not be delegated, which is why you cited the example of the police prosecutors, as we call them.
Yeah.
You cited that example. So the position of the AG again is that prosecutorial powers may not be delegated to a juridical person. By virtue of Article 88, the AG again argues that the powers vest solely in the Attorney General. The office of the Attorney General has always been seen as, in our jurisdiction, an office wearing many hats.
Right.
In other jurisdictions, the Attorney General is government advisor, all right. But the Attorney General is equally a very independent person in the discharge of his or her duties, where the independence would mean that the Attorney General can prosecute appointees for not abiding by the Constitution or other laws. In our jurisdiction, yes, the Attorney General can also prosecute other appointees, sitting appointees. But we have often asked the question, practically, though the Constitution allows or grants the power, practically, is that power exercised? And this is not, again, let me say, this is not a Dominic Ayene matter.
Right.
It is not a Dominic Ayene matter. It is not a Kisi Ejabeng matter. It is not the judge of the High Court. It is not her matter.
It's a he, actually.
It's a he.
Yeah.
It's not his matter. Let us, for once, remove NDC MPP from these discussions, so we can. So let me take you straight to the Act, and let's start from the long title. An Act. Pay attention to the word too. An Act to establish the office of the Special Prosecutor as a specialized agency to investigate specific cases of alleged or suspected corruption and corruption-related offenses involving public officers and politically exposed persons in the performance of their functions, as well as persons in the private sector involved in the commission of alleged or suspected corruption and corruption-related offenses. So that's the investigative part that the court mentioned. And again, it cuts out the jurisdiction of the office. If it is not a corruption matter or corruption-related matter, it doesn't come under the OSP.
That's why when we saw in that Cecilia Dapa matter, when it says it bothered on money laundering, you referred the case to Iyoko.
To Iyoko, that this is not my portion. Take it to an authority that has. So the OSP has a specific mandate. For which specific mandate, the Act says the first thing it must do is to investigate. Mm-hmm. Let me continue with the long title. Prosecute these offenses. Prosecute these offenses.
The offenses investigated.
The offenses relating to corruption and other related matters. Corruption-related matters. Investigate these offenses on the authority of the Attorney General. Investigate on the authority of the Attorney General. So 3 things we'll pick from here. No, 4 things actually. 1, investigate. 2, prosecute. What are they investigating? Corruption and corruption-related matters. On what authority are they investigating? The authority of the Attorney General. Okay. Let's move on to Section 3 of... No, let's start from Section 2 of the Act. Objects of the office.
That's a portion I want you to read. Then we'll get onto the phone lines because Counsel Jean-Baptiste Aye just joined us on the phone lines as well.
So A, investigate and prosecute specific cases of alleged or suspected corruption and corruption-related offenses. B, recover the proceeds of corruption and corruption-related offenses. C, take steps to prevent corruption. Go back to A, investigate and prosecute. That has come up again. Let's go for the interview.
Counsel, good morning to you. I trust that all is well.
Yeah, I'm doing very well. Thank you, Marina. I hope you are doing well too.
Yes, by the grace of God, we're well as well. We've been taking the time to go through the provisions of the Constitution in relation to the Attorney General, the powers which have been granted unto him, and as well reading the Act, the OSP's Acts, specifically the objects, which quite detail the need for him to investigate and then prosecute as well criminal or corruption-related matters. Not all criminal matters, corruption-related matters. In light of these two, how do we take what was pronounced upon yesterday by the Leonard High Court Judge, Justice Eugene Nyante Nyedu, the general jurisdiction of the High Court yesterday?
Yes, thank you so much, Marina, and then good morning to your listeners. In fact, when I saw the judgment or the ruling, I wasn't too sure if I was reading well, because it's a bit difficult to understand. So I decided to go through and then understand what was really going on. And, High Courts, the matter was raised at 2 different High Courts, so the coordinate jurisdiction. But the criminal court decided to wait for the Supreme Court decision on that. But the decision of the General Jurisdiction Court, GJ10, is a bit surprising, because there are certain things that are basic that everyone knows. Number one, a high court cannot make a decision when it comes to a constitutional, or cannot make a decision in respect of a constitutional interpretation. And in this case, whether or not the provision of the Act, as in when I say the Act, I mean the Special Prosecutor Act, whether or not at this stage the office of the Special Prosecutor has the powers to prosecute. So, the argument is true. Some believe that based on I believe everyone understands, based on the provisional Article 88, that the powers of prosecution are vested in the AG. There's no discussion about that. I think where the discussion is whether or not, in this case, the powers is given just once, such that once those powers have been given to you, then I cannot interfere. You can do whatever you want to do. That's where the issues are. And again, it's basic that you can't use an enactment to amend a provision of the Constitution. The powers given to the AG is a constitutional provision. And the right thing to do, if you think you want to tamper with it, then will be to go first and amend it. But you can't bring an enactment by way of maybe Section 4 of the Special Prosecutor Act such to amend it such that we end up having an office of the Special Prosecutor who is independent of the AG. That would be a bit difficult. So, Marina, it was very surprising, and I feel that something was wrong with the decision, respectfully.
To the extent that this was done when the criminal division of the High Court, which was looking into the matter, decided to pause and refer the subject matter to not refer but await the decision of the Supreme Court. There are those who are beginning to read some meanings as to why the general jurisdiction would have been in such a haste to make such pronunciation. Is there a justification for anybody to want to raise those kind of eyebrows as to what all of you lawyers are telling us is a no-go area, and yet a justice of the High Court decides to clothe himself with those powers and proceed on that course of action?
Yes, there's a justification. So anyone who will be surprised or will be more or less troubled by that judgment, that person will be right. Because the other court, and right now, you see, the issue we are having now is that two different high courts. And a decision of a high court, one high court, is not binding on the other high court. And if you listen to the office of the special prosecutor, they say that they will go ahead. And the reasons being two. Number one, there's another high court that has more or less been on their side. And then number two, they believe that a high court cannot more or less by way of interpretation or so come up with a decision that, number one, is even before the Supreme Court, and number two, that has to do with the constitutional interpretation, which is left solely to the Supreme Court. So yes, there's a justification for people to be worried about the decision, and I'm still at a loss that what could have happened, said that the court will make that kind of decision, especially when the AG is not complaining. The AG has not come to say that the Office of Special Prosecutor is prosecuting without their powers. And in law, we call something presumption of regularity. So the presumption is that once the AG is not complaining, then there's nothing wrong. But if AG is not complaining, and then it's more or less like, with the greatest of respect, the court seems to be descending into the arena of conflict, or be taking side and be playing a role of a party when the party has not even asked the court to do so. So that is it. But by our training, usually when this happens, we like to refer to the court, not to the individual of the judge, but the court, because it's a decision of the court. So that's why I keep on talking about the court, not the specific judge in the matter.
No, not the specific judge in the matter. Considering everything that is playing out and this determination which is yet to be made at the substantive court clothed with the powers, meaning the Supreme Court, that application is expected to be heard somewhere later today, tomorrow. But it goes to the heart of the ability of the OSP to operate with a free hand, and also the perception about the fight against corruption. In terms of everything that we've seen, this challenge as to whether or not it has prosecutorial powers, whether or not it is independent of the Attorney General, at a time like this, where do you think it leaves us in the fight against corruption and the perception that it comes along with as well?
I think it does not leave us in a very good place, because, look, corruption has always been a campaign message for all the parties. And any party that will be able to fight corruption, in my mind, will be able to cure a victory, if you like. And I believe the job of the courts is to help effectuate justice or fight corruption as well. But if we are now in a situation where some think that the court is aiding, the fight, that's what some think. And, well, everyone is right to have their own determination of the matter. But some think that the court is aiding in fighting against corruption. It does not leave us at a very good place at all. So, for me, well, and then the other issue is, I understand from the reading of the special prosecutor, he seems to be taking a position that he will continue with their cases and go ahead with their cases that the public more or less should, if you like, should not take that judgment to be is that they will relent or they will stop their work. But again, it comes out with a different school of thought, because every lawyer knows that when a court makes a decision, that even if the decision is wrong, it's binding until it's overturned. However, if it's a judgment per incuriam, then the argument is that you don't go by it. So will the special prosecutor continue? If it does, what will be the effect of it? Or will the special prosecutor stop and wait for the court to make a judgment? I think this was uncalled for, if you ask me respectfully, and at this time, this shouldn't be happening.
Well, on the OSP, they've been sharing on social media this morning that they will be returning to the High Court. There's another High Court. So they put out a statement today that Republic versus Issa Seidu and 3 others rice scandal case, that the Office of the Special Prosecutor will return to the High Court Criminal Division 1 this morning for the hearing of a bail application concerning the second accused person. At yesterday's sitting, the court was informed that the second accused person had been arrested at Kuruka International Airport while attempting to leave the country without permission in breach of his bail conditions. They appear to be going on with what has been their mandate before this pronouncement was made. There are those who say that not appealing it just as yet could raise matters of credibility. I've heard you on the per incuriam that, if it is a nullity to start off with, then they should be able to proceed and go about their duty. You don't see any challenges for them here today?
I don't think there will be any challenge. In my mind, I think they should be able to continue the case with the jurisdiction. But, of course, if the case were to be before the same judge, the GJ10, then it will be a bit difficult for OSP to continue the prosecution. But because the case is not before GJ10 and is rather before a different court, and I just told you that when it comes to high courts, they are of the same level, coordinate level. So it's not binding on the other court. This morning, in my mind, the special prosecutor should be able to continue the matter before the criminal court. But obviously, it doesn't speak well of the judiciary, and it doesn't speak well when it comes to the fight against corruption, and it doesn't speak well when it comes to fairness and justice, when seems to be going against each other. And for the layperson, they think that the law is clear. So how come you present the same fact before two judges, two different courts, and then they all seem to be going different direction and all that? So the special prosecutor should be able to continue. If I were him, I would go ahead with the case.
On that score, a simple argument can be made that the persons who the OSP will be seeking to have remanded, one of such who attempted to break their bail bond per what it is that he put up on social media, they could object to his appearance, considering the fact that another high court, yes, they don't have, it's not that decision is not binding, but they could argue in court today that his powers to prosecute are being questioned, and so they object to him being present in the court and wanting to have their clients remanded.
Yeah, Marwan, the line was going a bit bad, but if I hear you well, you are saying that they could argue in court based on the judgment given by GJ10.
Yes.
Yes. Well, if they argue that, that would be a matter before the judge for the judge to decide, because as I said, a decision of the court, even if it's wrong, is still in effect. So in this case, the decision of the criminal court is that they are not suspending the matter, or they are not, they are going ahead. It stands. So if you have issue with it, you make an application before the court. The other party will respond to the application. Then the court will rule. But you can't just stay in the house and say that because there's a decision, you will not appear before the court. If you do that, for those of us who do criminal cases, we always advise our clients never to try that, because the court can issue a bench warrant and your case will become even worse.
Right.
So if they believe in that, they can make that case before the court, and the court will make a decision, and then they will move on. But I expect the court to carry on with the matter.
Absolutely. I'm going to get into a bit more of hypotheticals right now, per what is expected before the Supreme Court and a decision that could be taken. Now, should we have, and I say should we have advisedly, a situation where the Supreme Court agrees with Noah Damte and the Attorney General, considering that the SP is not a party to the suit, and yes, arguments have been made that they don't need the presence of the SP to arrive at a conclusion which is different from that which has been canvassed by Noah Damte and the Attorney General. But should we have a situation where the Supreme Court and the justices there agree with the argument put before them, what then becomes of the prosecutions currently being done by the OSP?
Okay. Yes, should the Supreme Court agree with the reliefs of the plaintiff, which, per my understanding, I think they should, would that affect the investigation, the prosecution, and all that the OSP has done?
Investigations, I'm sure, can proceed. Investigations may proceed,
what I was going to say.
But the prosecution is where there are concerns about as to what happens to the prosecutions, because he has a number of cases in court, one of such which he's returning to court today for.
Yes. So in my mind, it won't bring to a nullity all the way that the AG, the special prosecutor, has done. No, I don't think so. But what it will mean is that at every stage, the Attorney General can step in and stop the OSP when it comes to investigation. So they will continue with because the issue has to do with whether or not the office of the OSP is independent of the AG. And then if the court rules that it's not, then all the prosecution, all the trial, or the cases that the OSP is doing will still go ahead. But in this case, the AG could intervene, just like Ioko and the rest. Their cases will still go on, but it will not affect that. But again, it brings a different question, because when you are interpreting an act, you look at the purpose. And the purpose for the establishment of the AG is to remove it under the control of the purpose for the establishment of the OSP is to remove it under the control of the AG, because the argument has been that the AG could not prosecute his own colleagues, people that he sits in the parliament or he sits in the cabinet with. That's why we came out with the AG. We came out with the OSP. But if we decide that no, the OSP will take authority or will take directive from the AG, then in this case, that's where people will be asking, did we go or did we come? Because it will bring us to square one, and that will lead to just a multiplication of functions and with not results. So, Marina, I think that the case will still continue, but the changes that will come is that the AG at any stage could come in and stop the OSP at any level, or could give direction to OSP to do ABCD, and OSP will be under obligation to do it. That will be the change that will happen.
I want to hold you just briefly on the line and have Christian Malmhesi as well join us. He's a private legal practitioner as well. Counsel, appreciate you as well for joining us on the telephone line this morning. I'm sure your reaction will be no different from the many that we've been hearing as to the surprise as to the basis upon which the High Court judge reached that decision. I've been looking around and asking, and for a lot of people, for the lay people who are listening, they ask, so what happens to a judge when they make a mistake like this? Is it just allowed to go? It's one of the many questions that has been asked. I'll ask you that question later, but I want to pick it from what happens to the powers of the OSP, considering what has played out in the last few days, the perception which now will be circulated in and around the office in itself when they do begin to make appearances, one of such which is expected today, vis-a-vis this ruling and pending matters before the Supreme Court, which they are not a party to and there are no counter-arguments to as well.
Good morning to you, my brother, and thanks for having me, and good morning to my colleague as well. The point is, indeed, if we are, this was embodied on interpretation, and if you look at the case of Republic versus High Court, ex parte Rollins, Justice Atuguba made a profound statement when it comes to the jurisdiction of the High Court in dealing with interpretation of statutes and even constitutional provision. Indeed, the Supreme Court is vested with interpretation of constitutional matters. However, it says that in that particular case, Justice Atuguba indicated that when it comes to basic constitutional interpretation, the High Court can proceed to make that interpretation. But the test case or the litmus case that Justice Atuguba indicated or opined in that case is that where the constitutional provision is ambiguous and admits different meanings and interpretation as of right, the High Court ought to refer that matter to the Supreme Court for interpretation. So the question that we should be affected with is, as the matter went before the High Court, in looking at section 4.2 of the OSP Act, vis-a-vis that of Article 88, the details of the text and context ambiguous that admits different meanings, which would create the reason for the referral. If in the mind of the judge, the text and context, the plain language, refers nothing more than what it is, then in the law of interpretation, the High Court would be said to have made the right call. But if there is room for ambiguity, such that the text and context gives meaning which will be at variance, then whatever step the High Court took, we can conclude that it was erroneous. Now, for me, I am of the opinion that the text as Sixtus was reading, I do not have the act here, so I cannot quote it verbatim.
I have.
Can you read it?
I have the object
so that the listeners can
right.
follow
so,
my argument. Yeah.
Section 2 of the OSP Act 2017, yes. Act 959, object of the office. Yes. So 2, the object of the office is to A, investigate and prosecute specific cases of alleged or suspected corruption and corruption-related offenses. B, recover the proceeds of corruption and corruption-related offenses. And C, take steps to prevent corruption. That is to the object of the OSP's Act.
Now, please proceed. He read the other part that dealt with the prosecutorial thing.
Establishment of the Office of the Special Prosecutor, Section 1. Section 1 1. There is established by this act a body corporate with perpetual succession to be known as the Office of the Special Prosecutor. 2. For the performance of its function, the office may acquire and hold mover. Okay, I'll skip that. Then I will jump to 3. To achieve the object, the office shall A. Investigate and prosecute. So Section 3 of the OSP's Act, functions of the office. To Section 3.1, to achieve the object, the office shall A. Investigate and prosecute cases of alleged or suspected corruption and corruption-related offences under the Public Procurement Act 2003, Act 663. B. Investigate and prosecute allegations of corruption and corruption-related offences under the Criminal Offences Act. C. I'm not going to read all of it. C as well. Investigate and prosecute alleged or suspected corruption and corruption-related offences involving public officers, politically exposed
and then the part
persons.
that talks about the part that deals with the Attorney General. That's where I want you to go to.
And persons in the private sector involved in the commission of the office. The bits that talks about the Attorney General involving politically exposed persons. Let me get that for you briefly with respect to.
So okay, while you take time to get that, now you would realize that just from what you have read, and if you read further down, the OSP is vested with prosecutorial powers. We shouldn't deviate from that. Now, the point is, these prosecutorial powers is subjugated to the Attorney General. That is so because even in the Act, it says that they have to procure authority. Now, it basically means that whenever it does all its investigative works and it's seeking to prosecute, it needs to get clearance, leave, as we say, permission, or notify the Attorney General that we have done A, B, C, D. We are proceeding to court. So give us that leave so that we go and prosecute.
Let me read.
This is not new.
Counsel, I have that portion you're asking for.
Please read it for
that's
us.
a long title.
The
959th Act of the Parliament of the Republic of Ghana, and says an act to establish the office of the Special Prosecutor as a specialized agency to investigate specific cases of alleged or suspected corruption and corruption-related offences involving public officers and politically exposed persons in the performance of their functions, as well as persons in the private sector involved in the commission of alleged or suspected corruption and corruption-related offences, prosecutes these offences on the authority of the Attorney General and provide for related matters.
It's specific. It's specific. The OSP has been vested under statute with that prosecutorial power, but is subject to the Attorney General because the powers of the OSP is deemed as subjugation of authority, that it is operating under it. The OSP aspect can at all times prosecute. If you go down to section 4.2, it further says how it must seek leave and all of that. So now the point is that prosecutorial powers has never been taken away from the OSP. I've said a number of, which I humbly believe they are quite misleading legal arguments. That says that by this, the OSP's prosecutorial powers has been taken away, and it is a sad day for the fight for corruption. And no, that is muddying the waters and misleading public education. That is not the point. The point is the court is only trying to, or the act is stressing on a legal procedure, and that procedure is what it feels as though is backfiring against the OSP. That the OSP didn't exercise that little step in seeking clearance or leave from the Attorney General in order to carry out with its prosecutorial agenda. And I believe that going forward, that should be done because the fight against corruption is a collaborative effort, and that is what I see the framework of the Constitution embedded in it. So, for anyone to say that indeed the procedural powers has been taken away is quite misleading. And then my final point is that, yes, it is quite sad that this has happened. Indeed, we shouldn't see or have the perception as though the AG and the OSP belong to different fields. It should be that they all stand on one field fighting corruption. Unfortunately, this has happened. But the point that is according to the case that I mentioned, and there are other litmus test cases like the my campaign case, the other cases that the Supreme Court has strenuously dealt with when it comes to jurisdiction as to interpretation of constitutional provisions and statutes, and that which affects the High Court in interpretation. And the Supreme Court indicated that if the litmus test is not established, then it would mean that any constitutional provision, any word of provision which does not require interpretation, which is not ambiguous and does not admit to a differential of meaning, would come to the Supreme Court, and the Supreme Court will be inundated with or overwhelmed with a lot of matters. So the exercise of wisdom probably would be that while there is a matter already at the Supreme Court which is dealing with the same case, the High Court could have exercised that discretion to prefer or stay proceedings for the court at the apex to deal with it. But it also does not preclude the High Court. When the High Court is of the conclusive opinion that it is not one of ambiguity and does not admit to differential in terms of admitting to various meanings.
Let me come to the both of you in concluding on these arguments. That can we say all of what it is that we're seeing play out can be attributed to perhaps the lack of the OSP to have landed a major conviction, which could have, in the minds of a lot of people, dispelled all of these conversations about prosecutorial powers and all of that. There's a select group of individuals who are of the opinion that, well, we've given the office some long room up to a point where we would have expected major convictions, which would have even convinced all of the people of Ghana to back the office at a time like this. We haven't seen that. And so even now, a lot of people are not even minded to want to participate in this debate and push for this independence which the OSP is seeking. I'll start off with you, Councilman Hesse, and then Jean-Baptiste will come in last. Hello? Council, can you hear me? Well, it does appear that both of them cannot hear me just as yet. Councilman Hesse, can you hear me, please? Council Baptiste Ayaja, can you hear me, please?
Yes, I can hear you, Marina.
Okay, so on that question on if all of this, to an extent, anybody would say, had they landed a major conviction, perhaps it would have quieted the storm as to independence and all of that. They haven't done enough to prove to people that they are going to do a good enough job, and so even if these matters are coming up, let's look into it properly. Is there any room for such an argument?
Marina, personally, I don't think there's any room for that argument. Of course, I have my personal sentiment when it comes to the working of the office in respect of whether or not we are having value for money. But in the case that we are dealing with, I'm not too sure how prosecution or conviction, securing conviction has to play. Maybe if there's anything that will have to play, maybe a seeming, maybe a friction between the office of the special prosecutor and the attorney general. If you remember, Honorable Ken Oforiatta case where the AG was asking for the docket and we heard the docket were not sent. It's like there's this back and forth that seems to suggest in the public, in the eye of the public, as if there's a power play where there's a suspicion or there's, this understanding that the OSP is being reluctant or deciding when to send what. So for me, maybe that could account for the situation that we have at this moment. But when it comes to conviction, I'm not too sure about that. And I think that they should be able to work together. And if they are working together, this shouldn't be a major issue before the courts.
Finally, on that Oforiatta subject matter, because I asked a question first of what happens to prosecutions should the Supreme Court rule in a particular direction, what happens to that extradition attempt as well if it were to go in that same direction? Just briefly.
Oh, no, it has no effect because, you see, we need to understand how extradition works. Extradition works through the AG, the Attorney General. It's the Attorney General that does the work. So even though the investigation and everything may have been done by the Office of the Special Prosecutor, when it comes to the authority in the U.S., the only entity that they know, so to speak, is the AG. So it has no effect at all on that work because it's done by the AG and AGC has the power. So this decision will not alter or change anything in respect of the extradition of Oforiatta.
Counsel, I appreciate you very much this morning for speaking to us.
Thank you, Marina.
That's private legal practitioner and law lecturer at the University of Professional Studies, John Baptist Ayaja, speaking to us this morning on what has become a notable subject matter for conversation this morning here on the 3FM Sunrise and across the length and breadth of the country as well with respect to details from that High Court decision from yesterday.
They hustle every day. All these tears no be play.
Facebook and other social media handles. Let us know what you think as well. I'm going to read a number of them. This one by Kofi Bento is a regular these days on Key Points here on 3FM and on TV3. He says the law has been used to deliver a huge blow to the fight against corruption. OSP neutered I can't wait for constitutional review. Meanwhile, those being prosecuted have a new case to make, he Mrs. Atuguba spoke to my colleague Beatrice Sowa on this particular subject matter. It could be easily the mind's eye as to what possibly we could have the Supreme Court say in terms of a decision on the matter. Here's what he told Beatrice yesterday after that honorific lecture by the UPSA to Chachu Chikata.
With no money joined, I would have thought that the Supreme Court that determines
Immediately after that,
constitutionality.
Friends from GNPC.
But it's not so straightforward because
GNPC.
where the matter is straightforward, the court
From the Oxbridge Club.
might apply
Which
the
is
Constitution.
alumni
There's
of
difference between applying the
Oxford
Constitution
and Cambridge.
and enforcing the Constitution. It's a technical lesson.
And immediately after that, we
difference.
will have the CEO
And
and the
unless
whole
I
team
see the proceedings,
from GNPC.
I can't determine whether what the judge did fitted into application of the Constitution or enforcement, which belongs to the Supreme Court. What the court has done, and what I've read in the papers, is to take away the prosecution powers from the OSP.
Please be on standby.
But the investigative power,
Chief of
the
Staff.
power to investigate, I don't know what starts upon. So long as the investigative powers have not been struck down, maybe those
Thank you
can
very much.
continue. The High Court decision is not final. I think there's an appeal also. They can question it in the Supreme Court. Until the Supreme Court finally determines, we can't say that it's over.
You were Speaker of Parliament, is it not? Respectfully.
Yes, what?
You were Speaker of Parliament, but you think that the OSP, I mean the Office of Special Prosecutor, has outlived its usefulness, or at the time you had reason to preside over the business of having this bill passed into law?
Looking at what is happening and the flagrant abuse of human rights, and also the fact that I would prefer that existing institutions are strengthened rather than having multiplicity of them with all manner of problems for us. Go and look for the man in this particular office. No, he's not with us now. He's with another organization, and so forth. What is this? And I'm saying that we have had strong prosecutors before. If you ask lawyers who are old enough, they will tell you about men like Jekidako. Therefore, if you look at the benefit of hindsight, we better go and do Sankofa and strengthen the office of the DPP, Director of Public Prosecutions, and then do things straight and right and according to the true tenets of the law. That will benefit us, I believe, because they have got pride of ancestry, they have got a tradition, they have got the best practices, and the best practices must be maintained. They must be retooled. They must be strengthened as an office to help do justice in this country, rather than we put an office up today, tomorrow we change the name, another time we set up another one, and sometimes we don't even know which organization should investigate that. And sometimes there's a clash with regard to jurisdiction and powers. It appears everyone now wants to show how far it can also stretch its powers. We have to rationalize things and strengthen our institutions.
I think it's premature to call for the closure of that office. The unique thing about that office is it is the only anti-corruption agency that has prosecutorial powers to be able to prosecute themselves without going through the Attorney General. And so people had mistrust with the Attorney General because the Attorney General normally is a member of government and is a minister of state. And so they believe that the Attorney General will be very reluctant to prosecute his own. But if there's an independent office like the Office of the Special Prosecutor, it won't matter who you are. So I think we should give them a little time. Of course, people want to see, more prosecutions and more results. And so I'll just urge the OSP to speed up, some of these investigations and, show people that the office is still very relevant.
That's the President of the Republic, President John Dramani Mahama. Before him was Speaker Michael Quay, who oversaw the passage of the OSP Act, Act 959, which is now a subject of debate. We'll go for a break. When we return, we'll take all of this home, right? Stay with us. This is the 3FM Sunrise.
Have you heard the Peduasi Top?
Michael Quay coming back to say, look, we may have gotten it wrong.
Mm-hmm.
Then perhaps all of that will crystallize into some decision of some sort, which might not be too great for the independence of the Office of the Special Prosecutor, at least from all of the opinions which we've sampled here on the show this morning.
No, I think that this is just the first step. At least we are all agreeable that the decision was in haste. The learned trial judge could have referred that bit of it to the Supreme Court. But of course, as to whether you have the power to interpret or not comes down to that's the High Court judge. Whether the High Court judge can interpret a provision comes down to a number of factors. I think it was Senior Mam Hesi who laid down those exceptions.
Yeah.
And so, yes, I mean, that's the reason we have appeal processes. We have the remedies like certiorari. So the OSP can take this up. And I'm happy to see that quite a good number of learned friends are urging the OSP to take up the matter. And this is not because people like Kisia Jabing. No, it's because of the institution. So I keep saying that let us decouple the issues. Let us separate the issues. Understand why we are advocating for something. It's not about long before Kisia Jabing is gone, long after he is gone, the office will still be there. And maybe some of the people shouting crucify him now will change their minds then. So this is a matter that should concern every single individual in this country who is interested in the fight against corruption, who wants to see a change in how public officers conduct themselves, how our party politics particularly and governance is conducted. There's a matter that should interest all of us. So I will join voice with all those urging the Office of the Special Prosecutor to take this matter up. Let's let the Supreme Court look into it so that we can have a conclusion that
it's been in the offing for a very long time.
A long time. A conclusion that at least protects the office. And that's also a wake-up call for us to re-look at the independence of the Special Prosecutor. How do we cement it? Can we have a mention of it in the Constitution as we undertake the amendments? I think it's one of the proposals that the current SP himself made. I think he had audience with the Constitution Review Committee at the time.
I think in recent times as well, he's been speaking at
a CDD platform, yes, and he reiterated it's something he keeps talking about. So let us begin thinking about how to constitutionally entrench that office, the Office of the Special Prosecutor, so that we don't see this thing happening again. Whether we like it or not, corruption is here with us. How do we fight it? It's a question that must be answered, and it must be fought with clear, standardized procedure, and the weapons must be armed. You cannot have an institution that is investigating, and the decision to prosecute lies with the person that you want the institution to be independent from. So that if the executive acting through the Attorney General says, don't prosecute this matter, who are you to prosecute it? They will sack you the following day. We all know the reality. We all understand the practicality of our politics. So we cannot play the ostrich. We can't pretend that, nobody can do this or nobody can do. Yes, the current Attorney General might be fair-minded, might be focusing only on justice. His interest might be that if the letter and the spirit of the law must be followed, and that is what must happen. So the current Attorney General might not have a problem lending or reviewing dockets that come from the special prosecutor and then okaying them to go. But what happens if you have a different Attorney General who disagrees with the office of the special prosecutor, or a different Attorney General who even disagrees with the person of the special prosecutor? Then what happens? Personal conflicts will come in the way of the work, and you will see that they will be disagreeing and nothing will happen. There's a reason Martin Amidu was widely acclaimed as the founding special prosecutor, because we all know he's a no-nonsense man. We all know that he speaks his mind. We all know that he is principled. We all know that he is somebody who will not stand wrong, who will not stand corruption. And so when his name came up across the board, acclaimed, everybody was okay with him. But will we always find somebody like Martin Amidu? Even he who was acclaimed eventually fell out with the administration of the day. So there are factors that we cannot control. So the only way to guarantee will be to ensure that the office of the special prosecutor has a mention in the Constitution, so that the powers of the special prosecutor are clearly separated and distinct from those of the Attorney General's department and the Attorney General, so that we don't see these conflicts happening.
Absolutely. Sixes with that one. It will get us into birthdays. A number of individuals celebrating their birthdays today as well.
3FM Sunrise.